The revolution will not be right back after a message about a white tornado, white lightning, or white people.
I'm warning the American people today about Facebook. Folks, we have largely abdicated our inalienable First Amendment rights to a greedy corporate juggernaut that cares nothing about those rights and that only serves to serve itself greater and greater corporate gain. I'm exposing the situation in a legal setting as no other plaintiff ever has. I know this because I scour the Pacer website and the internet for other cases. And they know it too. And that's why they hired yet 2 more corporate attorneys from a boutique law firm to try to shut me down. That's 3 lawyers and at least 3 support staff versus little old me and Pepper the lawyer dog. All I've got going in my favor is a briefcase full of the truth. Move fast to break things, Mark? We'll see about that. You've broken enough as it is. Now it is time for the rest of us to take our rights back and to help make America great again, without you getting in the way.
Green Acres, Beverly Hillbillies, and Hooterville Junction will no longer be so damn relevant, and women will not care if Dick finally got down with Jane on Search for Tomorrow, because black people will be in the street looking for a brighter day. The revolution will not be televised. The revolution will be no rerun, brothers. The revolution will be live. The revolution will put you in the driver's seat.
Don't you touch my camera. Yeah. Don't you touch my camera. I want him arrested. Now he's on me. Oh, no. Oh, no.
However you want to describe it, it's cool. Chris King. I call him a gonzo journalist, kind of ripping from the Hunter S. Thompson days, that he's in constant search for the truth.
That's a good summary.
Yeah.
My name is Christopher King, and reality video is my game. I'm a civil rights advocate and a screenwriter. I'm also a former resident of Atlanta, Georgia, the home of VH2 Networks.
Now, they banned me for that, okay, because I was criticizing Facebook. So you have this hegemonic warlord mentality at Facebook, okay, out there just deciding at its whim and whimsy who it can censor. And that's not right.
You sign up for Facebook, you sign up for terms of service. Are you familiar with that?
Yes.
Okay. It says, the terms govern your use of Facebook and the products, features, apps, services, technologies, software we offer. Facebook's products are products, except where we expressly state that separate terms and not these apply. I'm a lawyer, I have no idea what that means.
Cooley is the law firm, and I'm the man. I don't trust Mark Zuckerberg, so everything I do must be documented carefully. And
Fair
that's
enough,
the
but
deal.
you don't have either my permission or the firm's permission to film in the building.
I will
so
respect
I'm
that.
turn it off.
I respect that. Now let's talk. As the Stranger wrote, this is the newspaper in Seattle, the Stranger wrote that there are issues with Zuckerberg, Mark Zuckerberg, and Facebook taking away liberties, unequally with regard to race. And so that's kind of important, given the fact that minorities have not had, traditionally the means of production in order to discuss issues of race. So why am I being banned? Folks, I think Facebook's going to have a hard time trying to demonstrate the absence of bad faith when they're supposed to be giving legitimate appeals, and yet they sat on mine for 2 weeks until I called attention to it and filed something in court. The next day later, they said, oh, yeah, you're still denied. Okay, so who else do I have? The Color of Change and the Center for Media Justice and the NAACP. Okay, a total of 79 different groups have come together to complain that Facebook is basically a fraudulent enterprise, and that it's abusing minorities, and that we don't have the voice that we should have. And I show some of this in my pleadings with the court. So we're going to talk about Facebook. Good girl. We're going to talk about Facebook right now, why I'm suing them, what their alleged offenses are, and who my silent partners are in this venture. These are establishment people, well-established people, attorneys, civil rights groups, all of them, who won't necessarily line up behind me because I'm not establishment. But they are echoing everything that I'm saying, and vice versa. So let's get right to it. David K. Lukemeyer. He's an attorney. He's one of the best in the country at this issue.
he has written amicus briefs alongside Facebook. And here's what Attorney Lukemire has to say about the situation. One thing is for certain, unless courts narrow their interpretation of Section 230, deserving plaintiffs will be without redress. He goes on to say that courts should almost never dismiss other claims such as allegations under the civil rights laws or breach of contract claims on Section 230 grounds, for they are much too far removed from the tort of defamation that 230 really sounded in to protect these providers. Okay, so that's the first thing. You've got Ryan J.P. Dyer. He's a local guy here from Seattle. He's an attorney who wrote a note for the Seattle Law Review, and he basically said the same thing. The relevant examples as to why I'm correct on liability and potential liability here, and why Facebook does not have a blanket immunity that they claim to have. All right. Another person, there is Mark Lucky, and Mark Lucky, of course, was the recently resigned, or is the recently resigned vice president of diversity at Facebook, who basically is saying that Facebook abuses blacks not only at the office, but also on the platform. And basically saying that the blacks are not getting a meaningful review of when they are put down, when the posts are taken down. Blacks are complaining about racism, we're getting shut down, okay? This is nothing new here, but I'm exposing it in a way that's never been exposed before, all right? And I have substantial experience doing this type of thing. As Facebook's lawyers just found out when they tried to criticize me and my litigation background. We're gonna get into that at the end of this video. Okay, so now the background of my case is that I've had 3 or 4 suspensions this year, all for complaining about racism. And a couple of them, I dropped the N-bomb, which I won't repeat here, because if I do, then Facebook might not let me post when they bring me back online, okay? But the Facebook policies say that you're gonna get a meaningful review, and that if you're in the protected class of persons, which I am, obviously, brown skin privilege, then you can use those words in a certain way, as long as it's in terms of like sarcasm or empowerment, things of that nature. And that's what I was doing. In one such example, I was talking about Facebook banning a black rapper, and I said, oh, all of us are dropping like flies, okay? They banned me for that, okay, because I was criticizing Facebook. So you have this hegemonic warlord mentality at Facebook, okay, out there just deciding at its whim and whimsy who it can censor. And that's not right. You have this entity with that much power. It can't happen that way anymore, okay? And Attorney Lukemire agrees, okay? So, I don't know what to say about that. The guy has written amicus briefs alongside Facebook. But do you think he's gonna leave his posh, probably 7-figure job with bonuses, as a partner to come help me? Oh, fuck no. It's not gonna happen, all right? But the common citizen who hears this and recognizes what I'm doing, you can help out. There you go. So now we come to some of the issues. Immunity does not exist under the CDA. It's not under Section C1. That's not the analysis. And I'll read the relevant case on that. Darna versus Google. Now, Darna lost the case later on because of other issues, but Darna says, all right, plaintiff's claim for breach of implied covenant of good faith and fair dealing, however, is not precluded by 230C1 because it seeks to hold defendants liable for breach of defendant's good faith contractual obligations to the plaintiff rather than defendant's publisher status. All right, that's the C1 protection. Now, even though the claim is based on the same factual allegations as plaintiff's intentional interference claim, the source of defendant's alleged liability is different. Get it? Got it. It's not that complex. The same set of operative facts can lead to 2 different theories of law. It's so simple, guys. All right? Now, I did go to a top 50 law school and graduate from Case Western Reserve University, but you don't have to do that. All you have to have is some common sense. All right? Yeah, and they go on to say in Darna that the removal still must be in good faith. Okay, so that's, I don't know why we're standing here, all right? Should be a Rule 11 sanction against them, if anything. So, the other case I have, that's Song 5 versus Google, the same thing. The Ninth Circuit saying that, hey, you can't just block content for anti-competitive purposes or merely at its malicious whim under the cover of considering such material otherwise objectionable. Therefore, YouTube in that case was not entitled to immunity from plaintiff's contract or tortious interference claims. Okay, so Song 5 lost later on for other reasons, but those other reasons are not manifest here. Okay, so if I have to go back and amend my complaint to include additional claims such as fraud or gross negligence, I can do that. I haven't amended my complaint yet. Not once, all right? So, they talk about the limitation of liability, okay? Well, guess what, folks? Limitation of liability clauses do not cover bad faith. That's kind of what I just discussed now, all right? Doesn't cover bad faith or fraud. How could it? It's ridiculous. You can't just write yourself out of a contract or write yourself out of liability, okay? You can't do that. So, the next thing they talk about is the selection of venue clause, okay? They might win on that, all right? But it's not absolute. This boilerplate language you sign off on, who knows? And they're saying that the case has to be heard in California. Well, and they proudly proclaim, we've never lost a case on this. Well, not in the United States you haven't, but guess what, brother? Canada just ruled against you on that. And the point in the Canadian case, the Druez case, is that these multinational corporations with all this power, they can go litigate anywhere, all right? But to make us go travel somewhere to litigate a case when they're gonna have to hire lawyers anyway, look at this. Is there equal arm's length negotiation going on into any of this? Absolutely not, okay? And they also talk about the fact that it's different with YouTube because, yes, it is the most popular channel, but there are other channels that you can easily, put your music video out there to mass public, all right? That doesn't exist with Facebook, okay? Because we all heard that debate this summer with, God, what's his name? I can't think of his name right now, but the debate with Mark Zuckerberg, where, your monopoly. That was the whole issue. Yeah. Lindsey Graham said that. So we have different facts in this case, and they're gonna try to run me out of town. Here's the status right now. I filed the case. They filed for protective order, but first we had a conference on discovery, and they said we're not gonna respond to anything because we're gonna file a motion to dismiss. So I filed a motion to compel discovery. They got in a tizzy over that because I didn't wait for the responses. Well, I don't have to wait. We had our conference, dude, and you said you weren't providing anything, so I filed the motion to compel. Done, right? So then they come back and they file for protective order and refuse to answer any of my questions. And then I come back and I responded to that. And then they filed for motion to dismiss and I responded to that. And so this week the court's going to rule on the discovery matters and the protective order. And then there's an oral argument February 15th on the substantive issues. I've left out Mark Lucky a little bit, okay, because he talks about how blacks disproportionately engage with Facebook. He cites the data from the Pew Charitable Trusts, and he gets into all that. And what the problem is that he says we're still being mistreated on the platform. And so what I say to that is that thus, the same group of people who disproportionately drive the Facebook bus still sit on the back of that bus. Nothing has changed since the days of Rosa Parks, okay? And there it is, folks. There it is. And so so what Facebook did was they went in there. The first thing they did was try to attack me in their motion to dismiss. And I said, you know what, guys? I'll read you the first paragraph of what I said to that. I said, defendant's recitation of some of plaintiff's prior cases is completely irrelevant. Plaintiff is an investigative journalist who primarily sues for access and information and usually wins. And I have an index of my cases in the public interest, okay? I hold a mayoral commendation in the city of Nashua for my conduct and work in the First Amendment, all right? So, none of my cases have ever involved an allegation of frivolity or vexatious litigation, all right? So why is he mentioning a couple cases I've lost, or a legal suspension from 18 years ago, all right? Just denigrate the black man. That's what Facebook's all about. That's what Facebook's about at its campus, and that's what their counsel are trying to bring home too, all right? It's the same reproductive institution, and it must be slammed. Now, let's go to some of the cases that I put in my index, all right, about this. Oh, by the way, in Facebook, okay, they leave up posts, from white people talking about all life splatter, and we can get behind this movement and all of that, okay? You see that? That post didn't come down. That's because, well, we know why that is. And I says, you know what? You want to challenge me about my cases? They talked about the city of Seattle case. Well, guess what? There's, I won that case and I got information, documents that that it's an issue of corruption. Let's just put it that way, all right? And then in the city of Quincy, I sued them for information. I won that case, settled it, and then the information I got allowed a homeowner to finish his home. He's got a room in the house named after me, okay? Then I beat Kelly Ayotte in the town of Franconia in 2008, all right? Cost awarded to plaintiff because I had to sue to get information, dash cam videos about a cop being abusive to someone. After that, you know, George McNeil, Somerset Police Chief, says, keep up the good work, good stuff. You know, Jesus Christ, man. All right. You know, I've got video of me winning First Amendment trials online.
Police officers stand in a position of authority for a reason, a purpose. They went to school, they take some hard knocks, they deserve to be where they are. They are not infallible.
The jury in this case, being duly impaneled and sworn, find the defendant not guilty.
Thank you, Your Honor.
Yes, thank you, Mr. Chairman. I'm going to get my BMW. I'm out of here.
That's the case with right here with Alderman T-Boom. You know, we reversed a speech policy in the city of Nashua. The city attorney agreed with us. There's my commendation. It's basically like the key to the city. They don't give out keys to the city, but they give out mayoral commendations. In Ohio, I had 2 cops found to have made my client a victim of violent crime. I sued those cops. We settled for like 56 grand, you know, back in the 90s. They choked my client. I reported American Tower to Wage and Labor. They got fined 300 grand. I won a case against the city of Gahanna. They weren't letting people build housing for the frail, elderly, handicapped. I won an appeal, most of an appeal, for a former law enforcement officer in Whitehall. And when I was suspended for a year, I got a letter of recommendation from the Ohio State law professor stating that racism, ignorance, and reactionary politics were part of that suspension. Okay? Oh, and by the way, I lost a case to Judge Rumbaugh. It was a corruption case. They wouldn't let me run video in courts. Well, about, you know, a year later, I used the same memorandum and provided to this judge who complimented me on my integrity and knowledge of the law. All right? And it's all on video. And, you know, I says, look, guys, I'm a journalist. And that's why one of my cars proclaims that proudly. And that's the gentleman, the two of us, you know, we prevailed and we're able to run video in courts. It's a long story, folks. There's a lot going on. And Facebook wants to make it all go away, as if nothing happened. But something is happening. Keep watching. Mama, this one's for you. You told me 20 years ago to get a blog. Thank you. I love you. This is in 1998. She said, son, you need to get you a blog. You have a voice beyond the stuff that you're doing. You need to get you a blog. And I looked at her and I said, a blog? That's stupid. Who does that? You know?
I've tried a lot of cases in my life, Mr. King. I've never had the advantage of having a videotape to take home and review after the day of trial. Well, that's unfortunate, Your Honor, but I do have that. It's a modern era. Your Honor, lastly, I will state that the First Amendment is not something that you can have it in theory, you can enjoy it tomorrow. No, you enjoy it right now.
Johnny Cochran, the hell